A very, very good evening to all the friends that have joined and to many others who could not. I, Tisa Setalvar, on behalf of Citizens for Justice and Peace and PUCL Maharashtra, would like to particularly welcome our guest, Justice Paranthaman, who is a renowned retired judge of the Madras High Court and who very kindly consented to the release of this Citizens Human Rights Manifesto 2024. I'd also like to thank the panelists who will be joining us today, Henry Tiphagne, Aruna Roy, Anjali Bhardwaj. Thank you so much for being with us. I'll, of course, do a proper introduction as we go along. Before we ask our esteemed guest, Justice Har Paranthaman, to actually formally speak and release the manifesto, I'd just like to say at the outset what went into this entire exercise. India faces its 18th general election. We are in the midst of it right now. And we've seen in the past decade a real downsliding in the democratic rights of all people, and also the denial of structural inequalities, the scapegoating of minorities, Adivasis and Dalits, and the criminalization of protest and denigrating of fighting for a better world in the public sphere. So just like the PUCL and CJP has done in the past, we did not exist at the time of the emergency, but we've had a period in the past as well when we've had to articulate what the people want and why human rights needs to be centered at the very, very core of the political discourse, which unfortunately it is not today. So the idea behind this drafting and consultation behind this Human Rights Manifesto was simply this, that we actually articulate both in the arena of civil and political rights, economic rights, environmental rights, climate change. I mean, we have a host of subjects covered under this Citizens Human Rights Manifesto. And it was a fairly rigorous process. We began the drafting process, the teams of CJP and PUCL Maharashtra in August, September 2024. Then we went into a round of consultation, sought endorsements, after which we've got over 60 organizations and several individuals who have endorsed the manifesto. The process will not stop, and we will continue to try and dialogue. We see this as a dialogue tool for the human rights movement with the various political formations to ensure that the issue of human rights is centered in the policies that follow the election. There are 14 key human rights asks and one major demand in this document. And I will, of course, through the introduction of the panel, say a few more things about it. But right at the outset, I would like to invite our chief guest, Justice Har Paranthaman, to say a few words about the document and about the need for such a manifesto and anything else that he wants to say. But before that, a few words on him. He is known throughout Tamil Nadu and in many parts of the human rights community world as a people's judge, a person who speaks for the conscience of the people, who has a strong voice for social justice, and ever since his retirement in 2016 has been closely associated with people's movements all over the country, and particularly in South India. We really look forward to having you, sir, and we are very, very grateful for your presence. Over to you.
Good evening to everyone. I'm thankful to Citizens for Justice and Peace and People's Union for Civil Liberties, Maharashtra, for giving me this opportunity to release the manifesto relating to human rights and to say a few words on human rights. There are 14 human rights 14 human rights issues. There are certain issues that has a further classification. For instance, I will say a few words on that. For instance, the first demand or first request relating to human rights contains there are four issues within it. The first issue is the issue relating to right to freedom of expression, right to peaceful assembly without harms, and the right to form association. These are all guaranteed by our constitution under Article 19(1)A and 19(1)B and 19(1)C. And as far as the right to assembly is concerned, we know about the 144 proceedings under CRPC curbing the movements. And as far in Chennai is concerned, particularly in Tamil Nadu and Chennai, I think we are better placed than other parts of the country. Even in Chennai, for the past 50 years, there is a permanent notification curbing the protest on the streets under the City Police Act, under Section 41(2). That is a colonial act that is used. It is analogous to Section 144 CRPC. It is periodically it is extended. Therefore, if any society or any union or anyone wants to conduct a procession, peaceful procession in the streets, you have to get a permission from police. In fact, law doesn't require for a hall meeting. Still, it is required to get a permission to hold a hall meeting. When there was a large-scale protest all over India, including Tamil Nadu, against the Citizenship Amendment Act, in one of the IAS officers, by Kannan Gopinathan, he resigned as a protest. He came to Chennai to address a meeting. We were not, the organizers were not able to arrange a meeting. At that time, I was holding some assignment given by a High Court as an administrator. A hall was under my control. I was able to give that hall for that meeting to speak against CAA at that time. Therefore, these issues like the right to assembly and the right to association, that was called in question during the Chief Minister Jayalalitha period by invoking ESMA, Essential Service Maintenance Act. About 3 lakhs government employees were sacked overnight. The issue was agitated in Supreme Court. Of course, ultimately the agitating government employees succeeded, but they faced a brutal attack, including women were put in jail for so many days under ESMA. And we are also aware about how this right to assemble peacefully was faced in Sahinbag case. When the people, particularly women, protested in the streets, even in Chennai, there was a protest. There was no problem in Chennai, but in Delhi, that was questioned before Supreme Court. The organizers called to repeal the draconian laws. I may also say there are draconian judgments. The Supreme Court in the Sahinbag case held, in my view, had I been a judge, I will say in a word, because of COVID, that no occasion arises to determine on merits. I will say the issue will be decided at the appropriate time. But the issue was heard, and the Supreme Court held there is no right to protest on the streets indefinitely. Even peacefully, you cannot have a right to agitate peacefully indefinitely. There was no such judgment even during colonial period. I just want to put a question. If the agitation was against the Citizenship Amendment Act. So many applications, the persons moved with an application questioning the Citizenship Amendment Act in Supreme Court. Supreme Court is yet to decide the validity. It is indefinitely keeping it pending. But the Supreme Court said people cannot agitate indefinitely. These are all some of the issues. Something like the human rights activist and other environmental activists. Priya Pillai, she was issued a travel ban. A judge, a Delhi High Court judge, Rajiv Shakdar, quashed it. He was transferred to our High Court. Madras High Court. For quashing that. Nothing more than that. I don't even call him an activist judge. But that is relating to freedom of association, freedom of expression, and something like that, and also right to information. That goes from Article 19(1)(a). It is related to Right to Information Act. During UPA period, that act is, I think it is a milestone in the independent India. However, we know that the PM Cares Fund is beyond the scope of RTA Act. The name PM is used, and every government employee's salary is deducted, and CSR funds are taken. But you cannot get information under RTA Act. It is beyond the scope of RTA Act, and also it is not beyond CAG's perusal. Controller and Auditor General also cannot audit the same. Like now, electoral bond. Now, of course, so many details have to come about the electoral bonds and private corporations. We can't get information and from private corporation under RTI Act. That has to be expanded. And the present regime wants to curb, even to take away, and these rights, and we have to safeguard those rights. And see, then right to free media. I am not taking. I will conclude shortly. Right, you right to free media concerned. In my view, most of the televisions and print media are under the control of the party in power, and particularly for the past 10 years, every media is under their control. The only media that is speaking for people is social media. Even there, that they want to control by fact check unit. They call it FCU. But initially, Bombay High Court gave stay, but ultimately it vacated. Now Supreme Court granted stay. Otherwise, we cannot. Now we now use the social media platform by various Facebook or WhatsApp or YouTube. We use those medias. There will be censor, but unless this fact check unit, that is the fact check unit of the government, unless they allow it, nothing will come out to the public. And right to privacy also, that flows from Article 21, but that is also under attack. Already there are Colonial Act. Now the present day government also enacted to intercept our telephone, to tap for taping of phones, and we are also aware in what happened in Bigas's case. The Supreme Court did not do anything in Bigas's case. They did not force the government to come up. They have to force them to file an affidavit whether they have tapped the phones or not. It is unfortunate. That is how our right to privacy is safeguarded by the highest court. Like there are also other issues relating to Article 21. We seek for freedom from torture and degrading treatment. Unfortunately, we have not ratified the United Nations Convention Against Torture. First, our demand should be that they should ratify and thereafter we have to enact appropriate law in terms of that the declaration of the convention. And there is a demand for abolition of death penalty also. Now, because of our fight, the Supreme Court now it is not the rest of rare, and even a lot of now restrictions, we are able to save so many persons getting hanged or killed by the state itself by the death penalty. And one of our activists, Papa Mohan, when he is a special public prosecutor in a brutal murder case relating to a Dalit boy married a non-Dalit girl. That in that case, when the judge asked, he said, though as a public prosecutor, he is not for death penalty, even in the court. Ultimately, he got a life sentence. And I think everyone is aware about the Papa Mohan in Tamil Nadu, who is fighting for all these cases. And likewise, encounter killings. In UP thousands, in Tamil Nadu, one or two. Everywhere encounter. We can't hear in the Western world about encounter killings. And here it is very common. The very common is Tista is well aware about the encounter killing of Israt Jahan and Sheikh Sohrabuddin, wherein our home minister of the state was accused. Of course, he came out of it. Well, that is a big debate. And in judiciary, it itself will take a lot of time to debate on that. The person who was amicus curiae was not able to get the apex court derivation, Gopal Subramaniam, in that case, and others like Jayant Patel has to resign from the post for handling those cases. That there are so many other issues relating to that also, and also there are so many issues relating to human rights, and particularly the right that flows from Article 21, right to life, right to liberty, that is guaranteed under the Constitution as a fundamental right. We know in 2002, more than 2,000 Muslims were killed in Gujarat. The perpetrators were prosecuted by the organizer of this meeting, Tista. What had happened? She was sent to jail by the Supreme Court by a judgment. That judgment was authored by Justice Kanvilkar. Now he is a Lokpal chairman. That is what I want to bring here. And the person who initiated prosecution in those cases in favor of the victims is now facing problem because of the judgment of the Supreme Court for taking up the cost of the victim. And as far as this release of political prisoners are concerned, in Tamil Nadu, we are aware about in Rajiv Gandhi case, our cabinet took a decision to release those persons because they are incarcerated for more than 30 years. But the BJP governor, they refused to act on that. Therefore, they had to move to Supreme Court. Justice Nageshwar Rao who retired. Just before his retirement, he ordered for their release. And while that is the case relating to these persons, in Vicky Banu's case, they were released for 14 years. But here in Tamil Nadu, these people were in for 30 years. And as far as Muslim prisoners are concerned, all over India, even in Tamil Nadu, there are problems. Now the DMK government has released even those Muslim prisoners. They are in jail for more than 20-25 years. And we also see about the Sai Baba, the professor. What happened? Every time they approach the Supreme Court, stop it. It's the second time he is able to come out. And even the activists are in Bhima Gurkhan case. They are still under incarceration without any trial even now. We do not know when the trial will come to end, when they will, all of them will get bail. Only a few got the bail. So the central government uses income tax, and the Congress account is freezed. In Tamil Nadu, every political party almost they gave the advertisement, but except Congress. The advertisement is the one first page in all the dailies. This time Congress did not give any advertisement, maybe due to paucity of funds. And ECI, Election Commission of India, when they restrained the state governments to act after the declaration of election, they permitted all these agencies, the ED, income tax, CBI, all these instrumentalities, all these instruments coercive instruments in the hands of the central government, they are free to act. I think that these are all the issues the panelists will have a detailed discussion on this, and this is not for the manifesto is not for this election alone. It is for future.
So, friends, this is the document that the PUCL and the CJP have worked on together. PUCL, Maharashtra, and CJP, and we would urge friends in the human rights community and also in the media to please go through it in detail. It has been a labor of a lot of work and a lot of commitment by all our teams, and I thank each one of you for making this release possible. I just also want to say, before I request our first panelist to say a few words, is that today is the 3rd of May, which is the World Press Freedom Day, and India, as we know, has slipped 159 out of 180 in the World Press Freedom Index. It's also the 1 year of the terrible targeted violence where the state is complicit in the northeastern state of Manipur. And I think we all take this opportunity of reaching out to the people in Manipur. There are still 44,000 people displaced. We know that 7,000 homes have been burned, not any reconstruction or rehabilitation, and no justice, tangible sense of justice for the 200 plus victims who have lost their lives. So I would just like to also say that there are 14 key asks under different heads in the manifesto. I don't want to take up time by going through the whole manifesto. I'm expecting the panelists to do so. But the one major demand that we have is very, very crucial, because it's the issue of repeal of the weaponized laws that have been passed and some laws that predated this regime. So the decriminalization of certain laws, and therefore please go through the ask section very, very carefully, because right from the AFSPA to the UAPA and laws that have been passed in the last 10 years, there's a demand for the repeal of several laws, largely central laws, but even some state laws, which are actually affecting the possibility of a life without, hamperment, and also affects the fundamental freedoms of the right to life with dignity and equality before the law. Citizenship Amendment Act. We've had a series of laws passed to actually nullify the Forest Rights Act of 2006. We've had the 4 labor codes passed, which actually take away the labor rights earned over 150 years of struggle. So I won't list all these laws, but I think we are all aware of them. Please go through the asks, which is asking for the repeal of those laws that are also seeking to control freedom of the press, freedom of expression as well. Our first panelist today, and I thank each one of you for joining us, is Ms. Aruna Roy. Hardly needs an introduction. A very senior social activist and the founder of the Mazdoor Kisan Shakti Sangathan, which I think just 2 days back commemorated or celebrated 34 years of its founding. Aruna.
Thank you, Tista, and congratulations to the Citizens for Justice and Peace in PUCL Maharashtra for making an extraordinary document with all the components that we would desire to be in a manifesto. It's extremely important that there is a release of a manifesto on human rights in the context of the dismal state, not only of human rights, but all rights in this country, and the right to question, which has been completely under threat. And when the right to question is under threat, all rights automatically fall into the pale and its shadow. Congratulations again for an excellent document. It can become a premier document for undoing all the illegalities and the wrongdoings of the past decade. So no matter what the result of the election may be, we have a document with us which can be like a reference for carrying on with an active agenda for human rights and for demands and for the kind of action we would like to take. If the India Alliance comes to be, it can become the basis of a common minimum program on human rights, which we could then shape further and which we could debate upon. If the BJP comes to power, we have a consolidated list to demand the changing of the status quo and remedy the violations of laws which have been passed against the norms of the Indian Constitution. We endorse it. However, it could be a live document if there should be space for enhancement and some small space for small debates, not major debates, not fundamental debates. And its dissemination all over the country will allow for a lot more lively debate and discussion around this document. And I'm looking forward to the translations of this document that you can make and other translations that we all will help and support. Like we have quoted the Constitution, if there's a suggestion that maybe we could also indicate the violation of the UN Human Declaration of Rights, so that along with the Constitution, we also know what of the international regulations we have violated, and a critique of the violations of the standards of international standards of human rights, so that we get a more holistic picture and we not only look at India, but India in the context of the world and the global situation. In the RTI, I'm not going to talk long, it's going to be very short, but in the RTI, we felt that perhaps you could include Articles 14 and 21 as well as 19, because one of the principal slogans has been the right to life and equality, hum janenge, hum jiyenge, and also the demand for information has been fundamental to fighting the right to for poor people for existing with dignity. So the demand for information, actually we feel, the MKSS feels and many other organizations in Rajasthan have felt, should be made a fundamental right like the right to education, so that it doesn't stand contestation in small matters. We also feel that the enhancement of information like the use of digital data for people like the Jan Suchna portal in Rajasthan and now in Karnataka and possibly in Tamil Nadu should also be mentioned as means of fighting the digital attack on the right to information, which has been through so many sources, and I won't go into it because I don't have time. Also, another suggestion that all RTI defenders and whistleblowers should be brought under the category of the human rights defenders, because ultimately they're all fighting for rights related to basic fundamental rights. The Whistleblowers Act, Protection Act needs to be inclusive, and we should suggest that it brings in journalists, anti-corruption activists, and people fighting discrimination as well, so that it becomes a far more expansive and inclusive act. The one more thing in ask number 3, perhaps transparent to ensure that the vote is cast as desired, counted as cast, and to be declared as counted could be a concept that could strengthen it, and have the VVPAT in the hand of the voter to cast the vote. Actually, those of us who are in this meeting all understand it, but outside, in the outside universe, there seems to be some confusion still about this. So, of course, there are innumerable examples of discrepancies in the use of the EVM and the violation of the right to vote, which I won't go into because we're all well-informed people in this meeting today. In the right to work, a review of minimum wages is acknowledged as an extremely important issue because it's a matter of life and dignity and a right to livelihood of very many people in India. We applaud this effort, and in the end, we just request that all the party manifestos should have a reference of framework under the DPSP should also be a demand, so that the DPSP specifically gets covered by this manifesto, because that's where all our demands lie. Once again, congratulations and all our thanks for this extraordinarily good collective effort. We stand by you and stand with you. And in future, I think we should take this debate and discussion to as many places in India as possible. Thank you, and you must have spent hours on it, and I appreciate it, and we appreciate it. Thank you very much.
Thank you, Aruna, as always, to the point, very gracious and very, very comprehensive. We will certainly take into consideration all the points you have made. I think 1 or 2 of them are already there, but we'll go through them with a minute lens with you, because this is not a formality that we want to complete. I think any good suggestions should and must be incorporated. I'd also now like to call upon the second panelist today, very much part of all of us and the human rights fraternity, Henry Tiphagne, advocate and National Secretary of the Human Rights Defenders Alert India. Before I ask Henry formally to start and begin and make his contribution, and thank you, Henry, for coming out of your very important survivors hearing for this, I'd just like to emphasize that the introduction of this manifesto mentions clearly that as human rights groups and individuals, who are committed to a free and just India, we demand that governments abide by the implementation of the United Nations Declaration on the right and responsibility of individuals, groups, and organs of society to protect universally recognized human rights and fundamental freedoms. That is the Declaration on Human Rights Defenders. But yes, I think under every section, we can add a little line where we also have a corroborative match with international law that gives us a wider perspective, as Aruna had suggested. Henry.
In terms of human rights institutions in this country, the National Human Rights Commission is being grilled in Geneva in the Global Alliance of National Human Rights Institutions, trying to protect its status as an A-grade status institution before the subcommittee on accreditation. And none of us in this audience have any doubts that this is an institution which has been a wrong model not only during the tenure of the present chairperson, but also for the past several years. In 2011, they were granted an A-grade status. In 2016, after this regime came, they were downgraded. And it was only using political pressure because of the 25th anniversary of the NHRC in 2018 that they managed to get an A grade. And in 2023, because of the joint effort of civil society across the country and the reports that came from different parts of the country about how poorly the NHRC functions, last year in the month of March, they were put on deferral for 1 year. And this year in March, it was taken up for hearing. And this week, right this week, starting from 29th, the NHRC is appearing before the subcommittee for their attempting to see that their deferral is removed and their accreditation is granted. I am not for the accreditation at all, because we all need in India an upgraded human rights institution called the National Human Rights Commission. And this has to be a model for all the other 160 or 70 institutions we have in different states. And I therefore think that this should be one of our asks as well, putting the National Human Rights Commission in terms of citizens monitoring in front. I come from a state where we have had 16 killings in the city of Thoothukudi, in the Vedanta killing, as we call it. But it is a shame that the NHRC in the year 2018 ensured that this case was closed by it in a suo motu case that they had taken. And we can go on narrating incidents after incidents where they have not at all bothered to open their mouth when national and international reputed defenders were incarcerated, including Tista, who is coordinating this release. And therefore, NHRC and National Human Rights Institutions is one subject that needs to be brought into our manifesto. The second question is to ensure that we ask for a protection policy for human rights defenders in this country. I fully agree that every engagement in human rights, whether it's on issues of labor, whether it's issues of right to information, etc., we are defenders, but we need protection and we need a statutory protection policy. I don't think we can get any government to come out with a law, but a protection policy is a must, which is in the hands of non-state actors, not in the hands of the government. And these are two major issues. And the third, which is not found in our manifesto, is that this country, with all its talk, doesn't have a parliamentary standing committee on human rights. And that is a must. We need, for protection of human rights, our parliamentarians to be engaged in this discourse on human rights, both within and outside parliament. And many of the matters related to human rights, which have been rightly covered in the different asks, are matters which necessarily need to go before a parliamentary standing committee that shamefully we do not have in this country. And therefore, I fully support the points that have been made by my previous speaker, Aruna, that this is never too late. The elections are going on, but this is a mandate for ourselves. As defenders in this country, from different parts of the country, we take this manifesto. It is our duty to put flesh into it, to read it into our respective languages.
It very eloquently said, and the points very well made. I would like to just, before I formally ask Anjali Bhardwaj, who is a transparency activist and of course the co-convener of the National Campaign for the People's Right to Information, and has had so much to do with the recent developments when it comes to the public right to know in terms of public finance, just a couple of things I want to mention. There's a section in the manifesto on the rights of under trials and prisoners, which is very much there, speaks clearly about the bail and not jail should be the rule across all criminal laws. And I particularly am highlighting this because we are speaking at a very painful juncture in our country's history, where very, very dear, young, not so young, different genders, all sectoral, different kinds of activists have been incarcerated, and for 2, 4, 5, 6 years, even more, simply because they were defenders of their various sectoral human rights. Unfortunately, it's not possible to take everybody's name, but I do want to flag particularly the very young leadership of the anti-CAA agitation in the capital city of Delhi, who continue to be incarcerated 5 years, close to 4.5, 5 years down. And the judiciary, the role of the constitutional courts in hearing their bails is also something that is a matter of great, great concern to many of us. Anjali Bhardwaj, there's a whole section on the right to privacy that we have also spoken about in the manifesto, but I'm sure you have many, many comments to make. Over to you, Anjali.
Thank you. Thank you very much, Tista. And I would like to join all the panelists who spoke before me in thanking both the Citizens for Justice and Peace and PUCL Maharashtra for putting together this very powerful document, which very, very comprehensively lists what all we need to do to address the issues of human rights and uphold people's human rights in today's India. We know what the situation is. There are sharply increasing inequalities in the country, brazen crony capitalism, 9 families holding more than 50% of the wealth of our nation, with millions and millions of people living in abject poverty. We are seeing everywhere we go politics of hate, the kind of visceral hate we see in speeches of leaders of the ruling party, and divisiveness along caste, along religion, ethnicity. You talked about Manipur, Tista. All of this is being enabled in a democratic republic like ours with constitutional guarantees of fundamental rights only because people's fundamental democratic right to question, dissent, and protest is being systematically crushed. And we are seeing that there are at least 3 or 4 kinds of attacks that are happening. The first attack is on those who dare to question and dare to dissent and highlight what is wrong. So all those people who have been speaking out have been systematically labeled anti-national, terrorists, somebody will be called an urban Naxal. And there are cases under these draconian laws like the UAPA, PMLA, NSA that have been initiated against so many people who have dared to show truth to power. And we are seeing how laws are being systematically also trampled upon, those very laws which enable us to realize our constitutionally guaranteed fundamental rights. The right to information, like you mentioned, Tista, has been amended twice. The recent amendment that has come through the DPDP Act, the Digital Data Protection Act, which was brought in the name of protecting privacy of citizens and their right to information. It fails to do both. In fact, it has amended the Right to Information Act and put out of our reach a lot of information which is so critical for people to hold the state accountable. We know how people whose basic rights are not reaching them, right to ration, to pensions, to basic social security, use the Right to Information Act. Every year, 60 lakh RTI applications are filed in the country by people who are wanting to access information and hold the state accountable. all of that information which they have been speaking, which is granular information, often including personal data, has been put out of the reach of citizens. Information on who are the people who are walking away, running away with people's funds, public money from the banks that they're taking loans, these large capitalists whose loans are written off, all of that information is going to be out of our reach. And at the same time, the law which was brought to protect people's data and their privacy has set up a commission which is going to be completely decided by the central government, who's going to sit in that commission, and these people will have draconian powers of imposing huge penalties up to 500 crore rupees on anyone who violates this law, which has been condemned and criticized by not just transparency but also privacy activists. We are seeing how the right to information of citizens is being undermined by also bringing in these schemes and policies like the Justice mentioned about PM cares, similarly electoral bonds, where all of these instruments are brought in to essentially make sure that we don't have access to very, very important information which has to be given to us in public interest. We are also seeing how the NFSA, the National Food Security Act, has been undermined because the census, for the first time in our country, in independent India, the decadal census hasn't happened, which means that people who need rations in this high inflation economy, where there is such poor levels of employment, people need subsidized food grains, but all of them are being left out of the food security net because the census is not happening. We've also seen how laws like the Forest Rights Act have been undermined, and Whistleblowers Protection Act, which is supposed to help human rights defenders, actually also not even been implemented in the last 10 years by a government which came to power, a party which came to power on the promise of anti-corruption. And all of this is also being enabled by institutions that were meant to actually guard and safeguard our constitutional rights, which we are seeing their autonomy has been totally compromised, and compromised through various ways, especially by the way in which those who head these institutions are being selected. And today we have, unfortunately, institutions that are either not performing their roles or are being blatantly weaponized. So there are institutions like the Central Information Commission, where the central government, this government has the distinction of holding a record that in the last 10 years, not a single information commissioner has been appointed to the Central Information Commission till people have approached the courts. There are appointments that are not made to very many such bodies, which are supposed to guarantee us our rights under the Constitution. We know how the Lokpal has not been functional. There are no appointments made. And even when those appointments are made, they're made by a committee which has a preponderance of the government. These are still institutions which are just not performing. But those that have been weaponized, I think, are really what are going after citizens. These institutions are really enabling all of these laws to be used against human rights defenders. Laws like UAP, PMLA, we are seeing how the ED, the CBI, the IT department are in fact today just serving the interest of the ruling party and putting our entire democracy in jeopardy by either arresting the political opposition leaders or anyone who dares to dissent. And we know that in all of these laws, how process is the punishment. And like you said, for so many years, we are seeing how all of these people who have spoken out for us have been incarcerated. And I'm sorry, but the judiciary also we are seeing today that there is a huge problem. We've seen today Hani Babu again has withdrawn his petition, his bail petition, how civil liberties that we expect and hope will be protected by our judiciary, the judiciary is not playing the role that citizens in our democracy needed to play. So I really just want to end by saying, Teesta, that this is a very powerful, very important document that CJP and PUCL Maharashtra put together for us. And as we are seeing this, nothing was perfect before this regime came, but in the last 10 years, we've seen a huge backslide. And this is not going to be easy to reverse. So we need all political parties, including political parties in opposition today, to really commit themselves to everything that has been sought in this manifesto. Of course, there can be more inputs. It can be a live document, but we do need to really push political parties, the India Alliance and others, to say that, yes, if we come to power, we will adopt much of this or all of this if we come to power. Thank you very much, Teesta, and I'll stop here.
Thank you so much, Anjali. And I must thank each one of the panelists and Justice Har Paranthaman too for observing there. And I'm also very grateful for Anjali for bringing up something that has truly bitterly contaminated the public atmosphere in this country like nothing else. The kind of vindictive hate speech that we are seeing emerge on our commercial television channels. I refuse to call them national anymore. They have the same character of crony capitalism because they are actually owned by these mega corporations who have a close nexus with the party in power. And as we are seeing through this election campaign, we have the complete no-hold-barred, anti-constitutional language being used by men at the very top. And I think we know where it flows from, and the most despicable slurs directed at the minority community with words like jihad being manipulated in a very, very weaponized way. Our organization, CJP, is complaining. I mean, it's like 15 complaints a month against these wretched channels. And it's actually a mental health issue for our team because you have to sit and listen to those speeches and you have to transcribe them and translate them and then make an argument against them. And it's very not difficult to make an argument against them, but to hear the targeted hate speech that is being generated at a mass level, and then it takes almost 16 to 18 months for NBDSA to finally strike it down, by which time you already have 300, 400,000 views on that particular news telecast. Yes, it's a huge challenge, and we hope that we will together be up to the task. I'd like to now ask the General Secretary of All India PUCL, Dr. V. Suresh, to please kindly say a few words. Thank you, Suresh.
Thanks, Teesta. I would like to first congratulate the Citizens for Justice and Peace and also my colleagues in the PUCL Maharashtra for coming out with this very elaborate, exhaustive Human Rights Manifesto for 2024. It's very interesting that you are bringing out this manifesto after 2 rounds of elections, and there are 5 rounds of elections left, especially in the cowbelt states, especially in the states where we thought that it would only be communalism, it will only be hate, which will be the basic talking point. And suddenly in the last 10 days, things have changed. And then they are moving into talking about unemployment, they're talking about economic issues, they're talking about a whole lot of issues that we did not think would become part of the political language during elections. So I think it's very, very opportune time that this manifesto has been brought about and is now available for citizens to look at the entire range of issues related to human rights. What is very striking about the manifesto is for the fact that the manifesto moves beyond a very straitjacket understanding of civil liberties to look at human rights in its widest manifestation, covering the directive principles of state policy as also key elements of economic, social, and political justice, which is there in the preamble of India. Now, thanks to the present rulers and the way they have gone about it, they have now made the preamble a talking point of India. Across the country, people, I mean, we owe it to them because even lawyers had not read the preamble before the CAA protests and demonstrations came. We have to thank it to them that they pushed it in such a manner that today people are talking about the preamble. It is in this context that this particular manifesto becomes important now to be taken even to schools, to colleges. Of course, as a document, Tisa, you explained the hurry with which you brought it out. I think it could do with quite a bit of refinement, but we now have in our hands a primer, which could become like a charter of action over the next 5 years. I firmly believe that the poison of hatred and divisiveness that has been spread out in the last 10 years is not going to go away. It's there, it's rooted in our soil now, including in the state that Justice Har Paranthaman, Henry, and I come from, which is Tamil Nadu. Even here it's taken roots. Okay, and now it's a joint effort now to be able to take it out. Let's also not forget that some of the other political parties in the opposition have also been very soft on the Hindutva line and the majoritarian line. So it is up to us as a civil society and the range of activists that we have brought into one manifesto, this particular issue of how human rights is no longer civil and political liberties, is also democratic rights, is also animal rights, is also food rights, is also water rights, and a whole gamut of other issues. So I think, as part of PUCL, I would like to really congratulate the entire team which worked on it, and also my colleagues of PUCL Maharashtra State. There are a couple of key issues, I think, which now resonate, which I will build upon just as a point of discussion that we need to take it forward. The time has now come when we will now need to hold officials who have abused the law, who have deliberately and consciously misused the law, to account. We have to make them account by making them criminally liable for the abuse of power. So the whole principle of command responsibility and the principle of command accountability is something that's been long overdue, something that we in the PUCL have been asking for many, many years, which the time has now come. We now have so many examples piling upon each other, how in UAPA cases, the percentage of conviction is only 2.78%. There are 6,000, 7,000 people kept in jail for anywhere from 5 to 10 years. At the end of that period, most of them come out as acquitted. Now, what is the type of reparation that we are going to give them? There's nothing. Now, all the officials who deliberately did it and misused their power because of political reasons get away scot-free, because in our law, continuing with the old English law, we don't have a provision which penalizes them and makes them liable for abusing the law. So I think that is one aspect that we should build into this manifesto about the principle of command responsibility and command accountability and make them responsible. Here, I would also like to add that the principle of command responsibility has to start with the person at the top, not with the constable at the bottom. The constable and the sub-inspector and the inspector are only tools of the higher officials who are willing to sell their conscience for a price and remove their spine. We have to make them from the topmost, senior-most levels culpable for this. We will need to demand a whole lot of changes in the law currently, but I think that's part of the task before all of us in the democratic rights movement, not just the civil rights movement. Going along with the demand for inclusion of the right of for accountability also is a new understanding of the demand for compensation. The world is now no longer going back and using the term compensation. The world is now using the word reparation. Now, the word reparation in the UN sense is a much, much wider connotation, which I think we will now need to adopt in India. A few of us in the PUCL and other movements have been talking about it, but I think we now need to make sure that our demand now reaches a point in which we come out as part of the manifesto, a new law on reparation, following the UN principles on reparation, which are fairly well developed elsewhere. I, in particular, point out, because there is overwhelming statistics in India today, that the bulk of the victims of state abuse, and let me also bite the term that we need to use, of state terrorism. The state terrorism has reached such a point across India. State terrorism is not only in extreme cases like in Jammu and Kashmir or the Northeast or in Chhattisgarh. State terrorism exists all across the country. In different ways it's existing. We now need to also recognize the fact that the victim is not just the person who's been thrown into jail, but it is also their families. Now, this is the particular importance because 80% of all victims in India have been now researched to be part of the marginalized sections. They could be belonging to the Dalit section, they could be Adivasis, they could be Muslims, they could be various other economically marginalized sections. But it is them who bear an unfair brunt of the abuse. Now, international law recognizes that it is not just the person who's inside, the community which is penalized. Their children don't go to school. They don't get admissions in colleges. They are not able to access any of the public facilities. So I think along with this, in addition, we need to now start talking about the law of reparation as a separate law in which we hold individual police officers accountable and responsible to also pay for that along with the state. Now, the issue of weaponization and institutionalization and targeting the HRDs was talked about by Anjali. I think this is a very crucial issue in which we now also talk about how are these institutions manned or how are these institutions filled, including the judiciary. The judiciary, which is the holy cow, is something that we need to talk about. Now, the issue again of saffronization of the judiciary is no longer an issue of conjecture, is no longer an issue that you talk about in hushed terms in the court corridors or in small human rights groups. It is something which is facing us and facing us as a very grim reality. We need to talk about this. We need to talk about how are we going to ensure that we have a judiciary which is independent and which has not only independence but also independent will, for which we need to raise issues about the way the judiciary is manned across all levels, from the lowest level to the highest level. Now, we also need to talk about the fact of how the law is being abused by the right-wing people in terms of people who are raising issues of democracy and human rights. Now, the chair of today's meeting, the person who released this manifesto, Justice Har Paranthaman, himself is, I don't think he will agree to this word, but he himself is the subject of a complaint given against Justice Har Paranthaman just about a month back by a very important functionary of the BJP Tamil Nadu for having come out with a report just a little before the election started, talking about the type of hate politics and other crimes that is existing in India. So there is now a police complaint against him, asking that the police take action against him on hate crimes, against the judiciary, against the constitution, etc. This is the level to which we have gone to in the country. And this is something which we will now need to take to the length and breadth of the country for one single fact, that the present regime does not think of going to the lowest level of the human rights defenders. They are going straight away at the top persons, so that will become like a fear for anybody else who dare to challenge them. I think these trends are something which are very important that we need to expand in the manifesto. Use comics, use memes, use all the modern day forms that we have to be able to reach out to people to raise them. So this manifesto, there are two very key points, apart from expanding civil liberties into a larger human rights domain, which is that this manifesto has within itself, within the 20 pages of the manifesto, some portions which talk about the principles or the key jurisprudence that we want changed. This manifesto also has within it very important procedural safeguards which have been violated or which have been subverted. I think as common people and reaching out to the common people, we'll have to do both. We'll have to talk to them about the principle. We'll also have to talk to them about the way the existing procedural safeguards have either been subverted or completely thrown out, or something that which will need to be expanded so that there is greater protection for people through the procedural laws. Friends, I'm particularly emphatic about two things. One, we need to go back to the common people of India and let the common people of India file cases on hate crimes, on honor crimes, in every single lowest court of the country. Mr. Kanabran, the former president of PUCL, one of the most legendary lawyers of the country, continually kept telling us, don't think that the legal fight is only in the Supreme Court or the High Court. The fight has to be at the lowest courts. Just give you one example as to how powerful this can be. When the Sterlite incident took place, about 300, 400 people got arrested. When 13 of the people were shot dead were people of the community itself. They were arrested and taken to the Chief Judicial Magistrate. The Chief Judicial Magistrate, who had a certain human rights perspective, rejected and denied accepting the police FIR, saying FIR does not make out any case against them. He did not remand them. About 400 people on a day in which there was mayhem, those 400 people were given the protection of the law and let out on personal bail and not allowed inside. We have been documenting instances. They only one amongst many, many things, but at least those things are important, which is why this manifesto becomes important, that we write about the principle, we talk about the procedure. I would like to just end with one last thing. when you're talking about the right of association, the right to freedom of speech and expression, there's one thing that we need to talk about. While FCRA banning is something that we oppose, friends, we need to also acknowledge that the present government is using the banks and the KYC system to freeze or to close the bank accounts of many social movements. NAPM had its bank accounts shut down some years back. We have been having troubles even in PUCL. Various other institutions have that. They have been using the law of the banking system, apart from FCRA, to also throttle associations and groups from using or taking recourse to bank. If you don't use a banking system, you then become liable for changing in terms of money laundering. You use a banking system and the bank accounts are closed. This is how democracy is being throttled in India. I'm just bringing it to the attention because underlying this issue is not the issue of a bank account, it's the issue of association. On one hand, free speech is throttled. On the other hand, association is throttled. One, by way of preventing you from opposing or from protesting. On the other hand, from you in terms of existing. There are many other issues that we could talk about, we could add, and that we would need to write about, but I think that can wait for greater time. We now have a document which is elaborate, which is expansive, and which is comprehensive. I would like to therefore thank you on behalf of the larger human rights community in India, both the CJP and the PUCL Maharashtra, from coming forth with this at a very needed time. And hopefully, at least in the next 5 rounds of elections, this will add weight. Irrespective of which party, I think we need to push this in different ways. And CJP has a fantastic set of young people who are able to come out with very attractive ways by which we can approach the younger people. So I'll stop here and say that at least now we have something concretely to go to people with. Thank you.
Thank you, Suresh. As always, a lot of very good suggestions. And I'd like to now conclude today's meeting. I wouldn't like to call it an event. It's a meeting of like-minded people and media people with just 2 or 3 points. That one issue when we speak about, repealing of the extremely egregious and discriminatory CAA 2019, we have to also factor in, which also reflects in the manifesto, the kind of trauma and torture the people of Assam have been going through for the last, since 2009 at least, in an extremely misguided documented citizenship process, the NRC exclusion process, and also the D-voter and the declared foreigner process. So that is also factored here, and the way the foreigner tribunals operate completely out of the pale of the constitution and the law. Again, a pre-independence diktat, which is executive orders, which is allowing them to operate. And there are many issues, therefore, where we need to join campaigns to ask for complete change and reform. And in the section of the rights of religious, linguistic, and ethnic minorities, and I particularly thought of this when Suresh was mentioning so aptly, the need for a comprehensive law on accountability, command responsibility, and reparation. That post-2002, particularly between 2004 and 2011, there was a movement in this country for the tabling and enactment of the Prevention of Communal and Targeted Violence, Access to Justice and Reparations Bill, which of course dealt with a certain kind of violence. But I think the principles that are incorporated in that document are certainly something we should go back to, because it has very carefully enunciated the issue of command responsibility, that bill. And when the Akshardham judgment came the same day as this party was voted to power in 2014, advocates for all of the accused who were acquitted after an excruciating 7 years, including torture in the Gujarat crime branch custody, prayed for reparation because there was nothing found against them. And unfortunately, the statute itself under which they'd been incarcerated has a very convenient provision that does not allow for these officers to be robustly prosecuted. And therefore, I think that is a very important point that was raised aptly at the end of today's meeting. And I would personally like to thank all the colleagues and friends in PUCL Maharashtra. We work so closely together on so many issues. Mihir, Lara, and of course, Sandhya, Chainika, and others who helped with the document. And my own young colleagues at the Citizen for Justice and Peace, Tanya, Tamara, who have really worked night and day to ensure that this release happens before the elections are over. Thank you very much, each one of you. And I do hope that we are able to collectively use this document in all its manifestations and forms, including some of the suggested improvements and changes, to be able to take to the political class, to be able to take to the people, to be able to, it becomes a dialogue tool for the promotion and assurance of human rights of all kinds. And yes, the right of workers, the right of farmers was also very, very important and integral to this document. And that is why we've tried to be as comprehensive as possible. Thank you very, very much again. And for all of you friends at such short notice to join today's meeting. Thank you.